talk a little bit about the relationship between the statute, which, if I understand correctly, is what the law is, and the administrative code, which is how we do the law, and how that has led to things like having now to sign for every piece of ammunition that you buy?
Well, if I understand your question, I mean, a statute is enacted by the legislature. It lays out, it basically sets down what the law is. We have administrative agencies that carry out the law, and they enact regulations. An important question is what can the agency do other than literally what the law says? I mean, the agency will set rules. So, for example, in the case of firearms, the state police are empowered to enact rules and regulations with respect to firearms laws. In the 1 gun a month situation, the 1 gun a month law lays out certain exemptions for collectors and competitors, and one of the arguments that we made in the beginning of the case was that the police hadn't promulgated regulations or forms so that you can apply for those exemptions. The legislature said, yes, under the following circumstances, collectors and competitors are exempt from the restriction to purchase a 1 handgun every 30 days. Okay, fine, I'm a collector. I want the exemption. How do I get it? You can't. There's no way to do it because the police hadn't promulgated regulations or forms to apply for it. So we went into court and we argued that these exemptions are in the law, but they don't exist. And of course, the state police then ran immediately and enacted interim regulations and created a form. But the question of how far an agency can go in how they do it is one of the very important questions about the authority that agencies have. Because one of the arguments that you make is that the agency has gone beyond their statutory authority. We actually have a case that we're about to file an appeal relating to environmental law. I think as Frank mentioned, one of the things we do a lot of environmental and real estate law at my firm. And the DEP, Department of Environmental Protection, undertakes to implement the environmental laws. Well, sometimes DEP just makes stuff up. We've seen situations where they'll create forms that, does that really have a basis in the statute? The Spill Act or ISRA or one of those statutes. We have a situation right now where DEP has tried to enact a regulation which we think there's absolutely no basis for. The statute doesn't authorize it. They just decided that they want this to be a rule. Well, we're going to be filing a lawsuit to challenge that. So yeah, I mean, that's actually a very important aspect of how this stuff works, because one of the things that regulatory agencies can do is they can actually push the law farther than they really should.
Now, as much as we'd all like to keep Dan here for the rest of the evening, we're going to have to limit it. So one more question? Okay.
Sure.
Okay. I was wondering if you could talk for a minute about, there's, in New Jersey law, there's really 3 areas where you can get in trouble for possession of a firearm. One is 2C39-4 that says you can't use a weapon, including a firearm, against the person or property of another. So that covers criminal intent. Then you have 2C39-7 that says if you have a violent criminal history, or you've been institutionalized for mental health issues, or you're drug addicted and some other things, that you can't be in possession of a firearm. And both those 2 statutes make it a second-degree crime if you are in possession of a firearm. Then you have 2C39-5, which if you already can't be in possession of a firearm for a criminal purpose, and you can't be in possession of a firearm if you have criminal history, then 2C39-5 must be everybody else, which says you can't be in possession of a firearm basically without a permit is the short version. And with handguns you can't get a permit. With rifles and shotguns you can get an FID card, but there are limitations, and the rest is by exemption. So now that an individual has the right to keep and bear arms for lawful purposes, doesn't 2C39-5 address all the lawful purposes, since 39-4 and 39-7 address all the other purposes? And is that kind of, I don't want to ask you what your strategy is in the new case, but is that what you're getting?
Well, it's an interesting question. You know, I mean, what you describe is kind of one of the odd things about New Jersey law. You know, you can be punished if you're doing something wrong with firearms, obviously. You can be punished if you're the kind of person that shouldn't have firearms. And then you can just be punished if you're a regular person, you know, which is essentially what you just said. And it's that regular person stuff that really does kind of make you think, well, you know, in Heller and McDonald, we have the right to keep and bear arms. You know, one concept is that there probably ought to be an obligation of the government to show why you shouldn't be able to possess firearms. You know, there's this presumption against the firearms owner in New Jersey. There are several appellate cases which say that you own firearms at your own risk, that firearms laws are to be construed against the gun owner. That's a little crazy when you're talking about a fundamental constitutional right. You know, back in 1968, you know, we live in here in New Jersey, we live in a Burton versus Sills world, and we have for 40 years. With McDonald, Burton versus Sills kind of has to go away to a certain extent. You know, the Burton versus Sills world has to change, because this idea, you know, when you're the New Jersey legislature and you say, well, the sky's the limit, I can enact whatever law I want, because people don't have rights to guns. People have whatever rights we say they do. You can make crazy laws like, well, a handgun possession is illegal, except in this place, and this place, and this place. And if you're going from here to here, it better be, you know, you can't go for a pizza. That has to change. And I mean, I guess you kind of sort of zeroed in on it. That whole area of regulation has to, I think, fundamentally change. I think we're going to see it, like I said, either in the courts or the legislature or some combination of both.
Thank you. Didn't one of the opinions in McDonald versus Chicago hold that there are, unfortunately, there were reasonable restrictions?
No.
No?
No, although a lot of people say it. A lot of people say that's one of the things that really.
That's what I want to clarify.
Yeah. People talk about, you know, especially the Brady folks and the, you know, they say, oh, well, Heller, you know, after Heller came out, this was fascinating to watch. After Heller came out, I mean, Heller was just just a nuclear explosion, you know, against the gun control people. I mean, it just knocked them off their feet, or should have. As soon as Heller came out, they all read the case and they all announced that, you know, the Supreme Court upheld the right to enact reasonable gun laws. You know, and I'm thinking, well, I don't know what they read. I read the majority opinion, which didn't say that. But they talk like that. They keep saying that, you know, reasonable gun laws are permitted, reasonable gun laws. That's not a legal standard. And there's no holding in Heller or McDonald that says that. You know, the legal standard is absolutely critical. And when I say legal standard, it's how you measure the law against the Constitution. And that's what constitutional law is all about. How do we take this statute that's been enacted by the legislature and we compare it to the requirements of the Constitution and determine whether it passes muster or not? That's what it's all about. And that's when you hear things like strict scrutiny, intermediate scrutiny, rational basis review. Those are all levels of review. And the higher scrutiny you can require, the harder it is for the law to survive. And, you know, so the stuff about reasonable gun laws, it doesn't mean anything. It's just rhetoric.
Okay, guys, let's
Thank you.